They were specific to this case, but they were also of importance to practitioners generally. What I'd obtained is that in the trial of the appellant, there was a statement which was admitted into evidence, and that statement was recorded by a police officer. Our view was that that statement ought to have been, the learned trial judge ought to have, in her directions, made and consider the fact that that statement was merely recorded before a police officer as opposed to an independent judicial officer. The C.C.J, they dismissed the appeal. I don't think that much favor was found with that argument. As I said, it is a bone of contention for practitioners who have to contend with these matters in practice, you know. And then the second ground of appeal related to a transcript from a previous trial in which was admitted into evidence or found its way to the judge, but the fact is that the Court of Appeal found that was in fact an irregularity that ought not to have happened, but it felt that, well, whilst an irregularity, it did not raise to the level that it would have prejudiced or substantially affected his trial. We advanced the grounds, both grounds were advanced in the Court of Appeal, and we made the grounds here at the Caribbean Court of Justice, and the court did not find favor with the ground, and they made the decision, but the actual judgment that will be delivered at a later date, and we'll await that. I mean, certainly as practitioners, it will be very interesting to see how the court reasoned these provisions or these safeguards that we had argued ought not to, in the specifics of this case or generally, should not be given. So we'll just have to wait to see the judgment.